Law 578, Law of Evidence 2, Character Evidence, Lecture 3. Assalamualaikum warahmatullahi wabarakatuh. In this lecture, we are going to focus on bad character evidence. Now, what is bad character evidence? Or evidence relating to bad character, we find it under Section 54 of the Evidence Act. Now, if you look at the notes here, as a general rule, in Section 54, subsection 1, bad character evidence is not relevant. Now, let's look at Section 54, subsection 1. Previous bad character not relevant except in reply. In criminal proceedings, the fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character, in which case it becomes relevant. So Section 54, subsection 1 here provides you with a general rule in which it states that in the case of R.N. Whitemore, an accused person, basically, you cannot tender evidence of his bad character because it's going to be very unfair in the sense that you have to differentiate between character of a person with the crime itself. And this is the principle or the policy that is invoked by the law. Now, if you look at Section 54, subsection 2, Section 54, subsection 2 also reflects as a general rule that evidence of bad character cannot be tendered as evidence in the court. Now, let's look at 54, subsection 2. A person charged and called as a witness shall not be asked, and if asked, shall not be required to answer any question tending to show that he has committed or been convicted of or been charged with any offence other than that wherewith he is then charged or of bad character. Now, Section 54, subsection 2 also provides you with a general rule that if an accused person is called to give evidence in the court, he cannot be asked questions relating to his previous offences or previous conviction. So, Section 54, subsection 2 and Section 54, subsection 1 here provides you with a general rule that bad character evidence cannot be tendered. The difference between Section 54.1 and Section 54.2 relating to this general rule is that Section 54, subsection 1 provides you with a general shield that bad character evidence cannot be tendered, while Section 54, subsection 2 focus on when you are calling an accused person to give evidence in the court, he cannot be cross-examined, and if he is being cross-examined, there's no need for him to respond to any question relating to his previous charge or previous conviction. Now, if you look at the notes here, the case of Sterland DPP says that when a person charged or called as a witness relating to whether he has committed or been convicted or been charged, that particular phrase actually refers to that he must already been charged and convicted. Mere suspicion of crime is not going to fall under Section 54, subsection 2. Alright? And another difference that you have to bear in mind is that, as I told you earlier, Section 54 is a general rule on bad character evidence, whereby in Section 54, subsection 2 here is focused on the accused person. And under Section 54, subsection 2, you are talking about a situation where an accused person here is giving evidence in the court, perhaps on his behalf, on his own behalf. Now, if you look at the notes here, you find that this particular general rule under Section 54, subsection 1 and 54, subsection 2 provides you with a shield in the sense that the moment you have it provide for the shield in the sense that the law will not going to allow any bad character evidence to be tendered in court. And instances where shield remain intact in the sense that it is not regarded as bad character evidence is where it's not regarded to be broken, is where, for example, we have in the case of Gidari Lal, when you have a witness here testifying in the court relating to the identification of a photograph of the accused person. However, when the photograph of the accused person is displayed to the witness, it provides for some indication that he is a criminal, therefore it reflects his bad character. The court says that the evidence of identification via the photograph which reflect bad character evidence cannot be tendered as evidence in the court. Similar position was taken in the case of Lok Soha, and that is also where the general rule providing you the shield relating to bad character is given in the court. However, when you look at discussion on the case of Wong Po Hin that we have in the previous lecture, we find that if one evidence of bad character, so if one evidence is relevant under one provision of the law, and in the case of Wong Po Hin, it is standard under evidence of motive, you cannot bring evidence of bad character, section 54, subsection 1, to basically disallow for any evidence of bad character from being tendered. Alright, so that is a position of general rule relating to bad character evidence. Right. So what I'm going to discuss here, so when you talk about criminal proceedings, so you have bad character evidence. Now the general rule is provided for by section 54 subsection 1, and you have the case of Whitemore, where state that bad character evidence as a general rule not relevant, not admissible. And under section 54 subsection 2, when an accused person is giving evidence in the court, the accused person is provided shield in the sense that he cannot be cross-examined relating to his previous conviction, whether he has been convicted or whether he has committed a crime. So basically there is a protection or a shield protecting the accused person from having to answer question relating to his bad character evidence. So that are the general rule on bad character evidence. Now what are the instances where this bad character evidence shield broken? Now under the law, we have basically 4 situations in which bad character evidence can be broken. The first one, we are going to look at section 54 subsection 1, the proviso. We are going to look at it under section 54 subsection 2 subsection A, section 54 subsection 2 subsection B, and the last one will be under section 54 subsection 2 subsection C. Now, these 3 provisions provide you with a situation where the general rule on bad character evidence can be broken, which means that you can tender evidence of bad character. Okay, now let's look at the instances one by one. Right, the first situation in which bad character evidence can be broken, whereby we are looking at section 54 subsection 1. Now, when we discussed section 54 just now, it says that in criminal proceedings, the fact that the accused person has a bad character is irrelevant. So, section 54 subsection 1 provides you with a shield on bad character evidence. Any bad character evidence that is attempted to be tendered as evidence in the court cannot be brought in the court because of the shield given to the accused person. Unless, you have there the proviso, unless evidence has been given that he has a good character, in which case it becomes relevant. So this is a situation where the bad character evidence here, the shield has been broken in the proviso, and we have this in the case of R.N. Winfield. Now, how will this happen? Now, the shield can be broken basically in 2 ways. Number 1, a shield can be broken at the prosecution stage, and a shield can also be broken at the defense stage. Now remember, the proviso under section 54 subsection 1 says that, right, if you have an accused person here, A is being charged for bribery. A is being charged for committing bribery. Any bad character evidence relating to A cannot be tendered in the court. However, section 54 subsection 1 proviso says that evidence of A's bad character can be tendered if the accused person here brings evidence of good character. How can it be done? when at the prosecution stage, you have prosecution witness here giving evidence in the court. What happened if the prosecution witness give evidence in the court? The private prosecutor will do the examination in chief, cross-examination will be done by the defense, and then you have re-examination. Shield is broken when, during cross-examination of the defense of the prosecution witness, the defense here elicited good character evidence. So during trial, what happens here is that you have PW here being questioned in the court, and the defense here is inquiring relating to the accused person's good character. For example, maybe the defense is asking about the fact that maybe PW always have been always wanting to have money. So what the defense lawyer is saying that wouldn't A always give you money that you ask for? Yeah, this will reflect perhaps that the accused person here is of good character. He is being a generous person. So if that happened, the prosecution here can ask approval from the court to cross-examine relating to the accused person bad character evidence. And this can happen at the defense stage, right? So if you give evidence of the moment you give evidence of good character, then you open up the worms of can for all your bad character evidence to be asked. So that will be the first instances during examination in chief where the witness for the prosecution is asked relating to the accused good character evidence. So the shield will be broken. It can also happen at the defense stage, whereby at the defense stage, remember when we discussed about the position at the defense stage, here the defense, the accused person may be giving evidence as a witness. So he is now on the stand giving evidence on his behalf. Say for example, during examination in chief, he is giving evidence of his good character. So the defense counsel, his own lawyer, is asking questions relating to his character, and he give evidence of his good character. The moment he give evidence of his good character, then the prosecutor can cross-examine him as to his bad character. So that is what it meant by the position in the proviso to section 54. So you have here the shield is broken the moment you bring evidence of good character. All right. Now the second instances where shield can be broken is when we look at section 54, subsection 2, subsection A. Right, this is the second instances where evidence can be broken. Now let's look at section 54, subsection 2, subsection A. Now 54, subsection 2, subsection A, subsection B, subsection C can only be applicable where you have an accused person here giving evidence in the court. So you are in the position where the accused person here, during trial at the defense stage, while he is giving evidence in the court, he can be cross-examined by the prosecution relating to his bad character. Now, how will this be so? How can he now be cross-examined relating to his bad character? Because section 54, subsection 2 happened. Yeah, section 2A happens. Yes, so this will be the instances where the shield against the accused person, protecting the accused person here is broken. Now let's look at section 54, subsection 2A. The proof that he has committed or been convicted of that other offense is admissible evidence to show that he is guilty of that offense wherewith he is then charged. Now section 54, subsection 2A must be read together with explanation 2 to section 54, whereby explanation 2 to section 54 here says that a previous conviction is relevant as evidence of bad character. So when you have section 54, subsection 2A, you have to read it together with explanation 2. Now, instances where section 54, subsection 2, subsection A here applicable is where you have evidence which relates to similar facts evidence. So if you look at the provision here, proof that he has committed or been convicted of other offense is admissible evidence. So this provision basically says that an accused person has committed one action or has been convicted of the same crime before. So now what happened here is that the prosecution in the current charge wanting to bring evidence of his previous conviction, which happened maybe in a different time to a different victim. Now for section 54 subsection 2 subsection A to be applicable, since it is fall under similar facts evidence, the compliance to section 14 and 15 of the Evidence Act has to be there, meaning to say that before an evidence can be tendered to show his character, his bad character, the evidence of previous conviction must first establish or satisfy the link within section 5 of the Evidence Act. Now how will this happen? Right? This happens, say for example, you have A here. So you have A here, commit murder. Right? A commit murder of victim number 1. So the facts and issue here is whether A commit the act of killing victim number 1 or whether A here has the mens rea to kill victim number 1. So what you got to prove is to prove the actus reus and the mens rea. Evidence of murder, how he commit the murder of victim number 1, that is the modus operandi as to the commission of murder of victim number 1, is basically, okay, say for example, this murder happened in 1st of January 2020. It happens at Taman Tasik Shah Alam. It happens at 7 p.m. in which he dubbed V into believing that he has lost his dog, right? So he is asking V1 here to look for him, to look for the dog for him, and eventually he brought V1 to a bush and killed her, right? So that is the facts and issue, which happens on the 1st of January 2020. So you have this in 7 p.m. At 7 p.m. Now what happened here is that let's look at, say, instead of offense of murder, we change it to the offense of sexual assault. Yeah. So what happened here is that the facts and issue here is whether A assaulted V1. It happens on the 1st of January 2020 at Taman Tasik Shah Alam at 7 p.m. in which A pretended to look for his lost dog. So A approached V1 and asked V1 to look for the dog for him, together. And when they were at the bush searching, pretending to search for the dog, he sexually assaulted the girl. Yeah, so that is the facts and issue. Right. Now what happened here is that, so he is now currently being charged for this offense. What happened here is that A in 1998 has been charged for offense of sexual assault of victim number 2, in which this happened at Taman Tasik Titi Wangsa around 7 p.m. and he pretended to look for his lost cat. And he approached V2, brought her to a bush and raped her. Right? And as a result, in 1998, A was convicted of the charge and he has been sentenced to 5 years jail. And now, so in 2020, basically 1998, about 2000 in 2004, he is already out of jail. And again, katakanlah, say for example, in 2006, he committed the offense against V3, where it happens at Taman Tasik Shah Alam around 7 p.m. pretending to look for a lost dog or a lost cat, and assaulted V3 at Taman Tasik Shah Alam, in which he served the sentence 5 years, right? And he is now out of jail. Now what happened here is that in this situation, A is now charged for the offense of sexual assault of V1. Remember, you cannot bring evidence of his bad character, that he is a very bad person, he has been sexually assaulting people. You cannot give it as a general rule provided by the Shield under section 54 subsection 1. Even under section 54 subsection 2, as a general rule, he cannot be asked. However, in this case, if you can prove that the incident of assault of V2, V3 here is basically can be tendered to be relevant under similar facts evidence, then what happened here, the prosecutor would want to bring evidence of assault on V1, evidence of assault on V2 to prove that he assaulted, he want to bring evidence of assault on V2 and evidence of assault on V3 to prove that he now assault V1. Now the facts in issue will be whether A here assault V1, which happens at 2020, the year 2020. Now the prosecution here wants to bring evidence of the assault to V2 that happens in 1998 and the assault to V3 that happens in 2006. Now first of all, you have to establish the link between section 5, and the link is where you establish that the modus operandi is basically the same. You look at section 14 and 15, you look at the case of the test on similar facts evidence. Perhaps you apply Makin's test or special categorization, or you apply striking similarity test or Botman test. The moment this can happen, you can relate V2 incident and V3 incident to the current facts in issue. Then it will be relevant under similar facts evidence. Basically, it can be tendered under section 14 and 15. It can also be supported by section 54, subsection 2, subsection A, explanation 2. You can now be cross-examined, the accused person can now be cross-examined relating to the incident of assault that happened in 1998 and 2006. So the moment that happened, the accused person here must answer the question the moment they are asked relating to this. Yeah, this is where you are bringing in bad character evidence through similar facts evidence, and these instances actually has been discussed in the case of Junaidi. Right, in Junaidi, the position is that he was charged for possession of firearm and ammunition. Whether similar facts evidence that reflect bad character evidence can be relevant or not, by using the position under similar facts evidence section 14 and 15, the previous bad character evidence was tendered via similar facts evidence, and it can basically happen. So here, at the defense stage, right, when the accused here take a stand, he can be cross-examined relating to his previous incident of assault to V2 in 1998, an incident of assault to V3 in 2006 relating to the current charge. So this is what it meant by section 54, subsection 2, subsection A. You are tendering evidence of previous bad character, by tendering the previous conviction. Okay? So this is the second instance where shield is broken. Now let's look at the third one. The third incident of the accused bad character can be tendered is where you are looking in the context of section 54, subsection 2, subsection B. Right? Now let's read section 54, subsection 2, subsection B. He has personally or by his advocate, here is referring to the accused person. The accused person has personally or by his advocate asked questions of the witnesses for the prosecution with a view to establish his own good character, or has given evidence of his good character, or the nature or conduct of the defense is such as to involve imputations on the character of the prosecutor or the witnesses for the prosecution. Now, section 54, subsection 2, subsection B here, you can separate it into two separate discussions in which bad character evidence can be tendered if, number one, there is an attempt by the accused person here to establish his good character. Right, the accused person attempted to establish his good character. And the second one is where if you read the provision, nature or conduct of the defense. So you're talking about the nature or conduct of the defense is that the accused here, the defense here, is basically casting imputation as to the character of the prosecution or the prosecution witness. So here you are looking at the nature and conduct of the defense here, the way the accused person conduct his defense through his solicitor is casting imputation on the prosecution or prosecution witness. So we're going to look at this one. How does it happen? Yeah. Now let's look at the first part. The first situation or the first instances where character evidence can be broken is where the accused person attempts to establish his own good character, and this can happen where the accused person or his counsel during prosecution stage ask prosecution witness relating to his good character evidence. So you have a situation, this is what we have discussed earlier in section 54 subsection 1. You have the accused person here. So basically what happened here, A is now being charged for bribery. Right, you have prosecution witness here. Examination in chief is done by the public prosecutor. Cross-examination by the defense, and during cross-examination here, the defense here is eliciting good character evidence of the accused person from the prosecution witness. Right? So that is the position. So in this situation, bad character evidence will be broken in which accused person can be cross-examined as to his bad character. However, there will be no breach in the bad character evidence if, as what happened in the case of R and Red, if the accused person here, if the prosecution witness here is volunteering. So he volunteered to give evidence of the accused's good character. What happened here is that during examination in chief, during examination in chief, he voluntarily give evidence of the accused's good character, and in this instance, the shield is not broken. Alright, so that is the position. There are so many cases that reflect when the shield is broken. You have the case of R and Ferguson saying that he always go to the church on Sunday. In the case of R and Baker, he's actually earning honest living. The case of R and Coleman and R and Samuel. Basically, these are examples of common law cases where evidence of good character is elicited by the by the defense at the prosecution stage during cross-examination of the prosecution witness, right? Okay. The second attempt in which accused person establishes is on good character is where the accused person himself give evidence of his good character. So this happens at the defense stage, where during examination in chief by the defense counsel, A voluntarily give his good character evidence. The moment it happens, then the shield will be broken. Alright. Now under section 54 subsection 2 subsection B, the slight complicated area to be discussed that where shield can be broken under this provision is when you are talking about the defendant here casting imputation on the character of the prosecution or prosecution witness. Now, what does it mean by the defendant here or the accused here casting imputation? This is a situation here saying that perhaps you have in the case of R and Preston, where during trial, what happened here is that during cross-examination of the accused person, he claimed that the police has conducted identification parade improperly. So he is casting imputation on the prosecution witness, which is the IO. Now, what happened in this case? You see, for example, you have let's change the color. Okay, say for example, you have. Alright, A is charged for assault of the victim. So the actus reus and the mens rea is actually for sexual assault. Now what happened here is that when we talk about sexual assault, say for example it happens at 7 p.m. at Taman Tasik Shah Alam. And it happens on the 1st of January 2020, right? While the victim was jogging at Taman Tasik Shah Alam, she was pulled from the back and she was sexually assaulted. Now the victim here get the glimpse of the accused person, and what happened here? There is a need for you to have an identification parade. Now what happened in this instance is that during trial, when A is taking a stand at the defense stage, he is giving evidence of the fact that he says that the identification parade was unfairly conducted. He was basically, there was actually coaching on the part of the identification parade officer. That is what he said during examination in chief at the defense trial. So what happened here? You have situation where A here is giving evidence in the court at the defense stage, and he is casting imputation to the identification parade officer, saying that he is not being fair. So that is what it meant by casting imputation, right? So that is casting imputation on the prosecution witness. All right. Now, when you look at casting imputation here, right? So you look at section 54, subsection 2, subsection B. You're talking about the part where the defense here is casting imputation, right? Casting imputation on the character of the prosecution or the prosecution witness. Now, what happened here is you got to separate this argument when you are talking about other cases, and the other one will be rape cases, right? Because there's slight difference in terms of the law relating to character evidence. Yeah. Now, when you have other cases that is not related to law or to rape, now you got to basically look at what does it mean by casting imputation, right? What does it mean by, now if you look at the provision, he has position where the nature of conduct of the defense is such as to involve imputation as to the character. So what you got to prove here is that you got to look at the nature and conduct of the prosecution or of the defense case. Right? Nature and conduct of the defense case. When can the nature or conduct of the defense case here be regarded as casting imputation? So that's what it means that we have to look at. Now, on this one, you got to look at the case of R and Preston. Right? I have mentioned this case earlier. For a nature or conduct of defense to be regarded as casting imputation is where the defense conducting the case in such that he is proposing that the jury or the judge ought to believe that the prosecution or the prosecution witness to make that they are an unreliable witness. So what you are saying here is that the way the defense here conducting the trial and the way they ask questions in the trial is to basically convince the court that the witness here is unreliable and shouldn't be believed. So that is what it meant by that. Okay? So it is not simply so you are going beyond simply conducting a case, but the nature of you doing your case, the nature of you conducting the cross-examination, you are trying to basically convince the court that this person shouldn't be trusted. So that is the position, right? And you have this in the case of R and Preston. You can look at it in the case of Jones and DPP as well. All right. Let's look at so that is the position. And for rape cases, however, when you talk about rape cases, can you ask questions relating to bad character or not? Can you ask questions relating to bad character? Now, when you talk about rape cases, basically, now in some instances, if you have a situation where A raped B, B is a sexually active individual. So B here is sexually active. Right? So A is now charged for the rape of B here, and the issue here, the defense, so you have here the defense. So you have the prosecution witness here. Okay, B here becomes the prosecution witness. So he is actually giving evidence at the prosecution stage. Now what happened here is that the defense here, remember when you talk about evidence of rape, one of the elements that you got to prove, is basically penetration, and the other one will be whether she consented to the sexual intercourse or not. So consent is an element that you have to prove for rape, yeah? So when you ask questions, perhaps imputing on the character of PW here, who is the victim, and this is actually for the purpose of establishing the defense of the accused person, then basically cross-examination is allowed if you are asking questions on that is related to your defense. Because remember, as I told you just now, the defense is that, okay, you consented to it, therefore the prosecution witness here can be cross-examined to the incident of rape, whether she consented to it or not. It may reflect at the end of the day that the witness here may be some kind of woman of sexually active, or maybe she's a loose woman, maybe indirectly it reflects that, but the law says that it's okay because you are now here. It's very important that you are establishing the defense for the accused person. That is, you want to establish maybe the element of consent. You have these cases relating to rape, you have that in the case of Selvi. However, this witness here, that is the person who is the victim here, cannot be cross-examined as to her sexual activities with other person except for the accused person. Right? So that is the position on issues of casting imputation. Now let's look at a little bit of the law on casting imputation here. So we have discussed this one, section 54, subsection 1, proviso. We also have looked at section 54, subsection 2A, 2B, 2B. Right, we have looked into, the second part in which we are discussing now is where you have the defense here casting imputation on the character of the prosecution witness. Basically, how do you define casting imputation? There has been literal interpretation as to the meaning of casting imputation, and sometimes literal interpretation is that the moment you say that the accused person, you are saying that maybe the prosecution witness is actually a bad person or of bad character, it is literally regarded as casting imputation. They have been positioned under the law to say that, well, the shield is broken. But in some instances, you have to establish a bit more than a mere interpretation of the word casting imputation. You got to look at the nature or conduct of the defense. If the conduct of the defense amounting to unnecessary, unjustifiable imputation, then only it will be regarded as casting imputation. So you got to see here the approaches on the meaning of casting imputation. You have to basically try to say to the judge that you cannot believe, you ought not to believe the prosecution or the witness for the prosecution. You are saying that they are unreliable. So if the way the accused person conducts his defense is to establish as such, then that is amounting to casting imputation. Right? That is what it meant by this case, R.N. Brisbane and R.N. Hall. Now again, when we look at casting imputation here, so I separate discussion between other cases and rape cases, where if you have rape cases, to some extent, yes, you can ask questions relating to the character of the witness, but it will only be confined to establishing your defense, right? Here, But you cannot ask question over and above that purpose, okay? And in other cases, there's a difference between casting imputation and mere denial. Basically, the case of R.N. Brisbane and Hall provides you with the distinction between casting imputation and a mere denial. Right? So if you're simply saying that, right, he's a liar, right? He does not tell the truth. So it's merely a mere denial, then it will not going to break the shield. However, if you are being very mean, you say that he's a liar, whatever he say is you can never believe him, what he say, you are using strong word to reflect that he is a liar, then perhaps that is casting imputation. Right? You can look at those cases to reflect the distinction between whether it is a mere denial or casting imputation. Alright. Now, alright, the last incidence in which shield can be broken is where you have it under section 54, subsection 2, subsection C. Right? Section 54, subsection 2, subsection C. Now let's look at section 54, subsection 2C. The accused has given evidence against any other persons charged with the same offense. So here there's an element of an accused person here charged together with another person, co-accused, and he is charged with the same offense. So what happened here? You have accused and co-accused here being charged for the same offense, and A here is giving evidence, right? He may be giving evidence at the defense stage, and he is giving evidence, while he's giving evidence at the defense stage, he is giving evidence relating to the co-accused here. Right? If that happens, the shield can be broken, in which the prosecution can cross-examine the accused person as to his bad character. Now here, if accused person and the co-accused person is represented by different counsel, so you have defense counsel number 1, here you have defense counsel number 2, yeah, and you have the public prosecutor that is conducting the case. What happened here is during trial, an accused person here is giving evidence, and he's giving evidence of give evidence that may relate to the co-accused here, then the shield will be broken. The accused person here can be cross-examined either by the defense for the co-accused or by the prosecutor relating to the bad character. Alright, now what are the elements that you got to prove for you to apply for the shield to be broken under section 54 subsection 2 is that number 1, the accused person here must be giving evidence against. Yeah, must be giving evidence against. Remember, the first thing that you have to prove is that both of them are charged with the same offense. Yeah, both of them must be charged with the same offense, accused and co-accused. Evidence against here, you got to look at what does it mean by evidence against. You got to refer to the case of Varley and the case of Murdoch and Taylor. Now, evidence against here is actually referring to evidence which support the prosecution case at a material respect or which undermines the defense of the co-accused. Now, it means that if an accused person is giving evidence at the defense stage, he is giving evidence number 1 that is enhancing the prosecution's case against the co-accused. Yeah, he is giving evidence enhancing the prosecution case against the co-accused, or he is undermining the co-accused defense. So that is what it meant by evidence against. So for the shield to be broken, where A can now be cross-examined by the prosecutor or by the defense, by the lawyer of his co-accused, is when during examination in chief of the defense stage, he is giving evidence to the court that is either enhancing the prosecution case against the co-accused or undermining the co-accused defense, then he can be cross-examined. Now, different from section 54 subsection 1, 54 subsection 2A, 2B, yeah, all of that provision require the court to be agreeable to the conduct of cross-examination on the accused character. So the court must allow the cross-examination. However, when the accused person here is giving evidence against the co-accused under section 54 subsection 2 subsection C, it is an automatic right of the defense, co-accused defense and the prosecution to cross-examine as to the character. right? There's no need for the court approval for the cross-examination of the accused character to be done. Yeah. So it means that the judge has no discretion to refuse any application of cross-examination, and here the shield will be broken. Okay. Now, what happened in the case of Varley here? You have the offense of robbery and possession of firearm. They were co-accused, being charged together with the accused person. Right? He said that, right? The accused here says that I am involved in this crime, in this robbery, because I was forced by the co-accused. So you are basically undermining. So you attempted to, you got to see whether this fall under undermining the co-accused defense or enhancing the prosecution case. So that in this case, the court says that, basically what happens here is that after that incident happened, the accused person here tell the court of the fact that I was not there. It was the co-accused himself that was involved in the robbery. So the court says that yes, the shield is broken. You can cross-examine as to the bad character. So that will be the first one. You got to prove what does it mean by evidence against co-accused means. Yeah. Now, how will the court decide? How will the judge decide whether it is evidence against or not? You got to look at the case of Varley, whereby the court has to objectively look at the evidence. Yeah, it is for the court to decide objectively whether the evidence is actually supporting the prosecution case in material respect or whether it undermines the defense of the accused person. So it has to be subjectively assessed by the court. Alright? Now you have to understand that merely contradicting is not evidence against that may support the prosecution case in a material respect. So it has to have some significant meaning to the case. So it means that it must not only enhancing the prosecution case, it enhances the prosecution case materially. So it has to be significantly important for the prosecution. You are giving evidence that is significantly important to the prosecution, or you undermine the defense of the accused person. So it's not simply making a statement. If a statement is made but it does not contribute to any significant improvement of the prosecution case, then the shield is not broken. Yeah. So this one you can have a look at the cases that you can find relating to this point. Yeah. So basically what you have here, right, in the notes here, so you have interpretation of the same offense, meaning to say you have to be charged for the same offense. Now what does it mean by giving evidence against the prosecution, right? It undermines means that the acquittal of the co-accused person is less likely. So you are basically enhancing the material, the evidence, the case for the prosecution materially, right? So there will be instances where the shield is broken. So we have discussed so far. There are 4 instances of where the shield is broken. The accused person can be cross-examined, and when you talk about the co-accused, he must give evidence for the he must give evidence at the defense stage, and that will only be applicable when you are talking about a shield being broken under section 54 subsection 2A, B, and C. Whereas for a shield to be broken under section 54 subsection 1, the proviso, then there is no need for you to have an accused person and giving evidence at the defense stage. The shield can be broken by any evidence, and the witness can also be anybody. Yeah. And the last part of this lecture is looking at with regards to the cross-examination of witnesses. Basically, when you talk about evidence of cross-examination of the witnesses, you look at section 146, right? Section 146, okay, this area may also be relevant when we discuss about examination of witnesses. Now let's look at section 146 here. Question lawful in cross-examination, whereby when a witness may be cross-examined, he may, in addition to the question herein before referred to, be asked any question which tends to Number 1, as his accuracy, veracity, and credibility, right? So it means that during cross-examination, quite a number of questions can be asked during cross-examination. Among them is where the other party is cross-examining you to determine the accuracy, veracity, and credibility of your evidence. So you can be asked questions on that during cross-examination. Cross-examination will also be allowed to discover your position in life. And the third one will be cross-examination is allowed to shake the credit by injuring his character. So basically, to some extent, you can be cross-examined which injure your character, but when it falls under section 146 subsection C, right? And of course, when you look at this one, it may indirectly reflect to section 120 subsection 3. This is where you are talking about incriminating evidence. Yeah, evidence against self-incrimination. All right? Okay. So now, basically, we have completed discussion on bad character evidence. So this completes the discussion on topic 2 of Law 578.